Another witness, Xavier Torres, saying that Laquan McDonald was not acting in a threatening manner. That's the theme of the prosecution's case as they continue in their case against Jason Van Dyke. I'm joined now by Ashley Willcott, a trial attorney and frequent guest and host here on the Law and Crime Network. Ashley, as we move into this case, I'm finding the officer's testimony pretty compelling, although one of our producers commented they don't seem that happy, because we were listening to some of the officer's testimony before this witness, to actually have to be testifying against one of their own or one of their former own.
Right. I think that's absolutely true. They never want to have to testify against one of their own, so to speak. But the hard thing in this case is that the testimony of the officers I thought was compelling, but you have a video. And when you see that video, it's almost like, doesn't that say it all? You can tell that he's literally appears to be gunned down. So the video, I think, is the best evidence in this case, regardless of how happy or not they are to testify.
Absolutely. You can't get past that video evidence. It's hard to watch. We've showed it here many times. Jurors have seen many different formats of that video. I want to talk really quickly about something that happened in court yesterday when the prosecution had an FBI expert on the stand talking about some of that video, and the judge ultimately ruled that the jurors had to exclude all of that testimony. That was a pretty big blow to the prosecution, Ashley.
Yeah, I think it was, absolutely. But I think that, first of all, even if they tell the jury they have to disregard, can't take that into account, remember what the jury's already seen and heard, even though they're instructed not to take it into account. Second of all, I think that even if that testimony is not allowed, which the judge ruled that it would not be, the prosecution still has a lot of witnesses, evidence to produce that can be very compelling, and I think could still convince a jury beyond a reasonable doubt that this defendant acted in a way that he should not have, that amounted to murder.
Yeah, well, it's very interesting, though, that, you know, that misstep happened because with how much preparation that has gone into this case and how high profile it is in Chicago. I mean, this has been something that's really touched a chord in Chicago. There's been protests, et cetera, et cetera. You would think that the prosecution would have been fully researched in terms of their expert witness, that he was qualified to talk about these issues. That's just my personal opinion, Ashley.
Absolutely, you would think that. And I think the reality is the prosecution didn't expect it. They didn't do the legwork as much as they should have. They probably assumed the qualifications are there. But I still don't think they expected that the judge would rule that this expert could not testify as to that.
Ashley, stick with me. I know you're going to be here all morning. We're continuing to follow the Jason Van Dyke murder trial out of Chicago. We'll take you live there when we get our feed in. We're covering 3 other cases across the country as well. A lot going on here on the Law and Crime Network. Stay with us. We'll be back in just a few minutes. Just so very tragic to see some of these images, especially of what Laquan McDonald was wearing that night. I'm joined by my guest for this morning, Ashley Willcott. Let's talk about something that we were delving a little bit into earlier in the morning, and that is the fact that we had an officer testify saying that he did not see a threat and that he was waiting. He did not pull his weapon out because he was waiting for someone to arrive with a taser. Many things to dissect here. One is, you know, the fact that this officer thought there was no threat. But the other issue is that I didn't quite realize. Here you have Chicago, huge city, and not all of the officers have tasers. I think this whole thing could have possibly been avoided if each and every officer had a taser, including Jason Van Dyke.
Yeah, you hear, Rachel, so many police departments, everybody does have a taser to use because obviously it's not as lethal as using a gun, but obviously they don't have them in Chicago. And I do think the importance in that, though, is that he already testified he didn't perceive a threat, but obviously that perception was so clear that he was willing to stand or be in his car and wait while a taser arrived. So clearly he didn't feel like the defendant was, not the defendant, I'm sorry, the victim was a threat, or he wouldn't have just waited for a taser to get there.
Yeah, I found that very, very troubling because, again, you have him testifying to the fact of and a female police officer too, actually. They both talked about the fact that they had to wait for tasers, and repeatedly we've heard testimony he wasn't a threat. And like you said, that's the gun, by the way, that was used in the shooting. Like you said, the video is pretty clear. The guy was running away. However, I do tend to give police officers the benefit of the doubt. Sometimes it's dark, things are chaotic, but this is a situation where almost everyone we've heard from so far has had a different perception of the danger that night.
No, I agree with you. But the other thing that really bothers me is, regardless of the perception of danger, put that aside for just half a second, 16 times the police officer shot him. 16 times. And so that to me changes the perspective as well, because you think even if he thought he was in danger, that's excessive, I believe, in any circumstances.
All right, Ashley, let's turn now to Mark Messick. Let's listen to some testimony from him. He's the forensic video examiner from the FBI. And here's the interesting thing about this testimony. After it was done, the judge said that the jurors had to ignore it all. Take a listen to what this witness had to say. Okay, so some of that was silent, but I think it was important for you to hear the arrows, or where that FBI forensic video examiner are claiming that puffs of smoke were coming from. Ashley Willcott, why is that significant?
I think it's in terms of how many times he was shot, where he was shot, and where he was actually hit. And I think that he testified, and you look at that in conjunction with, if the victim was holding a knife, could it have looked like it might have been a gun? And where was he shot in relation to the direction he was walking? The puffs of smoke also indicate that piece. The point by the prosecution being he was walking away.
Yeah. And again, though, what's interesting about this testimony is this was really a win for the defense in a way, because it was stricken from the record. And we're going to get into some of that after the break. But why do you think something like this was stricken from the record?
Well, because of the qualifications. And so the judge has to determine, are the qualifications, the foundation for the person to testify as an expert, sufficient? They have to have knowledge outside the ordinary course of business of an ordinary person would have, right? And so if they have more knowledge in a special area, they can be declared an expert based on their training, their education, their experience. In this particular case, the judge found, based on the defense motion, no, they did not have adequate training to be declared as an expert in this area. And so again, you've already pointed out, Rachel, if you're an attorney, you want to make sure all of those qualifications are met prior to ever putting someone on the stand as an expert. So it is interesting that this was stricken from the record by the judge.
All right, Ashley, stick with us. We have a lot to cover here on the Law and Crime Network. We are following 4 major cases going on across the country. In one of the cases, Stanley Liggins, we're expecting closing arguments to begin any minute in that case. And when we have them, we'll take you there live. In the meantime, we're going to continue our deep dive into the Jason Van Dyke case. Stay with us here on Law and Crime. Okay, so some pretty skilled cross-examination by the defense of this FBI video examiner. Ashley Willcott, would you agree here?
Yeah, let's talk about that a little bit, Rachel. I like to see good trial skills, and that is something that this defense attorney is exercising. Notice that whenever the witness didn't answer the exact question, he was very kind and polite, but said, "Not my question. I'm being a little more specific. Here's my question." So he would calmly repeat it until he would get that witness to answer the exact question he wanted to know the answer to. The other thing that's really imperative is, it's interesting, prosecution has the arrows for the puff of smoke, brings that on direct examination. Then they object when the defense starts asking about the puff of smoke. And I agree with the judge, overruled. Guess what? If you bring it up on your direct examination, you've opened the door, and that's why defense has an opportunity on cross. So some really good, fun trial skills to see at work here.
But tell me this, okay? Why was this guy even necessary? Like, what? No, really. Tell me, Ashley, what was the prosecution trying to get with this witness? I mean, I get slowing down the video, making it clear for the jurors, but I don't think it achieved that much, even though it was stricken.
I think the goal was to say, let's enhance the video to show that there was no threat, to see what the child, it is the 17-year-old,
Yeah.
it's a child in my mind, was doing. Was there this perception of threat? How did he fall? Was he walking away? I almost think they went too grandiose, and the prosecution thought, let's show this to the extreme, so to speak.
Like if they hadn't done the whole puff thing with the puff of smoke and the arrows, I think we probably would have been fine with this guy's testimony, and it wouldn't have ended up a problem for the prosecution.
Oh, I completely agree with you, Rachel. I think you're absolutely right. So I do think that it may not have been necessary testimony, but in their minds, it was the right testimony to show how this was, there could have been no perceived threat at all by the victim.
Okay, so let's continue to listen to the cross-examination, because as Ashley pointed out, it was very skilled, and this was an opportunity where the defense really destroyed the prosecution's witness. Take a listen. Okay, so excuse me, the defense really trying to cut through the prosecution's witness, Ashley Willcott. How did they do?
Oh, I think they did, again, a really great job with their questioning. And keep in mind that sometimes defense attorneys can get really ornery, frustrated, and come across, I think, to jurors and anyone else in the courtroom observing as a little bit patronizing or picking on the witness or defensive. This defense attorney has a really good demeanor in addition to his skill set of asking his questions to get the specific answers that he wants. And he's honing in on the very specific details that he can then use in closing to say, guess what? Guess what well, in this case, this witness won't be heard from. But the defense attorney is getting all the little nuggets that he needs to put it together in closing to say, he shouldn't be found guilty.
Especially of those 2 murder charges. The other charges, perhaps, I mean, because when you think of strategy, right, it's not necessarily, the strategy by the defense might not be to acquit him of all of the charges. It could just be, we want to at least acquit him of the most serious charges, and how do we chip away at that argument? And you know what? I agree with you. These defense attorneys are doing as good of a job, given the case, that they possibly can.
Absolutely, I think so. And so you're right. There is one count of, I'm looking to see official misconduct, I think. And
Right.
That's the least of their worries, so to speak, when you're facing 16 murder charges. So as a defense attorney, it isn't all about let's get them out of all these charges. Like you said, Rachel, it's exactly about trying to get them out of the worst case scenario to the best case scenario, given what happened.
Okay, so speaking of skilled cross-examinations, let's listen to some of the cross-examination of Paul Rettig, another forensic video examiner from the FBI, who also did some enhancing of that shooting video that we've watched so many times. Take a listen. There you heard it from the doctor hired by the defense in the Cody Locke case, saying that this guy was insane, he didn't know right from wrong, that he was having delusions, that he thought that Lauren, the 13-year-old victim in this case, was an angel, and that she could not die. Ashley, are you behind this?
Let me just say, I felt like his testimony was a little bit kind of throwing everything in the kitchen sink, because everything he could think of came out in that testimony,
Right.
I felt like. So it's going to be a question of credibility by the jurors as well as what his actual testimony is. Note that he's young. Does that make a difference? Maybe, maybe not. But his experience is more limited given his age, I would suggest, than someone who maybe has been doing this as a psychiatrist for years and years. The other thing I had to mention is, as you well know, they have to show that the mental issue existed at the time of the offense. And so that this person, defendant, did not recognize what he was doing was actually wrong. And so now you've had all kinds of testimony about, well, he had so many thoughts going through his head. He didn't understand the wrongfulness. He had multiple diagnoses. He was delusional. He had a lot to say about why.
Because that's key in this, Ashley. That is key. It doesn't. People can have mental illnesses and still be found guilty of murder. The key defining factor here is that whether or not he knew right from wrong when he shot that little girl.
That's exactly right. I felt like he just threw too much in, so I struggled finding that the testimony was very credible myself.
Interesting. Okay, let's listen to a little bit more of this testimony because it is so crucial in this case. This is when the psychiatrist is talking about Lott's diagnosis and his history. Take a listen. Okay, so this is very interesting. This is the psychiatrist in the case of Cody Lott. He's the defense witness. He's talking about some of the mental diagnoses of this defendant and how he suffered from some of these disorders. Interesting, too, that he links some of this to marijuana use, Ashley Willcott.
Here's my problem. As a judge, I see, Rachel, all the time. You have defendants who have this kind of history, trauma in their childhood. They may have a psychosis that has to be treated. They may not. Drug use, how that affects. Everything I've heard so far, I see in almost every case that comes before me where there's a crime committed.
Murder? Is it an excuse for murder?
Right. I mean, I'm really struggling at this point in time to put it together to say, wow, he really didn't understand right from wrong. And like you said, marijuana use, opioid use, that does not excuse the crime.
Well, and something interesting, and I'm not sure if we're going to be able to get to it. I hope we are, because we have these live trials going on, so we might have to dip into a trial live. However, I don't know, Ashley, you might change your mind if you see some of the police interview of Cody Lott. Interestingly enough, this was not entered into evidence as part of the case in chief for the prosecution, but as part of the rebuttal case, they entered this police interview. They showed it to the jurors, and he sounds a little crazy in it. He does. So I'm assuming that's why the prosecution didn't use it. He confesses to the crime in it, but he sounds a little crazy.
And so, again, good trial skills, right? Of course the prosecution didn't use it because it's going to be something the jury sees as maybe he is crazy and he had this disorder and he wasn't able to tell right from wrong at the time of the incident. And the defense is very smart to use it in rebuttal.
Well, we'll certainly see what happens with that. I hope when we come back after break, we're going to show some of that police interview, and you can see from his own words how he describes what happens. And if you think he's insane, or you think he knew full well what he was doing when he shot that 13-year-old girl and injured her friend. Also, another major trial that we're following here on the Law&Crime Network is that trial out of Iowa involving Stanley Liggins. You can see a live shot from the courtroom in Iowa. The judge is gathering with the jurors, giving some jury instructions prior to the closing arguments. This is the case of the man accused of killing a 9-year-old little girl. We're going to take you live when those begin. Stay with us. A lot going on here on the Law&Crime Network. Okay, whoa. All right, that's a lot to digest right there. That was the police interview of Cody Lott, and you can see he confesses to the whole thing. Ashley Willcott, tell me, what are your impressions of that? He didn't seem all that with it, but could he tell the difference between right and wrong?
I mean, I don't think that interview in and of itself indicates whether or not he could tell the difference between right and wrong, which is why the defense hired a psychiatrist. But the thing I'll say, Rachel, is this. Who's to know if that was because of a mental defect and then he couldn't tell right from wrong versus, for instance, use of drugs? We know that the psychiatrist already said he uses marijuana, opioids, and methamphetamine. And so that could have been him talking fast and saying everything because he was on meth, which does not mean he necessarily didn't know right from wrong. So there's still a lot of questions even after looking at that police interview.
Yeah, I got to tell you, it certainly seemed like to me that he was high on something. The way he was speaking, the speed of which, the franticness of how he was speaking, he obviously was under the influence of something, if it was not some kind of psychosis like the defense contends. Let's listen to more of this recorded interview with Cody Lott, the defendant in this case. Take a listen. Okay, so this is a little hard to hear because this guy is just so manic. I don't even know how to describe how he's talking about this shooting incident. He murdered, well, he hasn't been convicted of that. He shot, no question, a 13-year-old, and he seems to be laughing about it and talking about some of the press coverage about it. And then he also said something that when he saw the description of the vehicle, I guess on the news, he realized he was effed. Ashley, doesn't that show that he knew what he did was wrong?
I mean, I would argue that, but I'm pretty pro-prosecution in general in my life. If I'm a trial attorney, as a judge, you have to be very objective. And so here's the question that I would ask as a judge and the evidence presented. Okay, so is the fact that he can say, this is what I did specifically in order to kill them and how I killed them and shot them, and it's funny and fun and games, and I think it's funny people think I'm a danger, is the fact he's able to articulate exactly what he did to shoot and kill the one girl enough to say that he knew right from wrong at the time it occurred? I don't know, but that's going to be the question. I find that if I just saw this video, personally, my opinion, I don't think it would make me he did not know right from wrong.
Ashley, okay, let's continue. As you mentioned, this is important. It was part of the prosecution's rebuttal case. Let's listen to just one more clip of Cody Lott's police interview. Take a listen. All right, we're listening to the prosecution's closing arguments in the Stanley Liggins case out of Iowa. That's the man accused of killing a 9-year-old girl back in 1990. As we've said, this case is interesting because his convictions, twice he was convicted, were overturned both times. The prosecution, Ashley Willcott, very carefully going through what evidence they do have, but this is a tough case.
Because it's circumstantial evidence, they have to connect all those dots. Here's the evidence, but I'm waiting for her to get to the really compelling heart of the matter to say, and this is why it's enough proof that this defendant did it.
All right, we don't want to take you away from this trial for too long, so we're going to take a quick break, and when we return, we'll take you back inside the Stanley Liggins case as they continue with those closing arguments. Stay with us here on the Law and Crime Network. All right, that's the prosecution of closing arguments in the case against Stanley Liggins. And you can see the prosecutor is describing the moments leading up to what is really described as a horrific strangling and murder and assault of this 9-year-old girl. Ashley Willcott, your time with me is almost up. You're not in that chair, but you are in Skype. What do we make so far of the prosecution's closing?
I think she's doing a good job of putting all the circumstantial pieces together. I wish she had a little more emotion in her voice or was a little more compelling. You know, closing is the opportunity for an attorney to really make an impact and really argue and convince the jury that that side is right. And I wish she had a little more oomph, but I think she's connecting the dots.
All right, let's continue to listen to some of the prosecution's closing arguments. But first, we have to take a quick break. So stay with us here on the Law and Crime Network.